Since 1966, this is NBC4's News Conference with Conan Nolan.
On this edition of News Conference, get ready for a major battle between doctors and the medical community and lawyers and consumer groups over a law most Californians don't know about. In fact, if you do know about it, it can get you kicked off a jury. It's called Micra, and it means if your child dies as a result of medical malpractice, the most you may be able to recover in court is $250,000, a sum so small most attorneys won't take the case. Critics say the limit on what can be collected for pain and suffering has allowed careless physicians to continue practicing without worry about being sued. The medical community is fighting back, defending the 38-year-old law, saying to change it would result in increases in health care costs and a reduction in patient services.
There's been an accident. The kids are hurt.
We talked with Bob Pack, an internet entrepreneur who lost 2 children and unborn twins to what he says was medical malpractice, but couldn't find a lawyer to take his case. Brian Kapitak, president of the Consumer Attorneys of California, and Dr. Paul Finney, president of the California Medical Association. Welcome to News Conference. This is a brewing fight between California's attorneys and the California medical community, and it has an impact on every man, woman, and child in the state. Brian Kapitak is president of the Consumer Attorneys of California, the group leading to repeal or to change the Micra law. Thank you very much for joining us.
Thank you very much for having me. I appreciate it.
I should point out you're a Los Angeles attorney as well. Explain in the simplest terms as possible what the Micra law is all about.
So Micra law is about medical safety. And Micra law goes back to 1975 when a law was put into place that caps certain kind of damages at $250,000. So today, that hasn't changed. It's still $250,000. And the life of a child is only worth $250,000. The life of an adult who doesn't work outside the house is only worth $250,000.
That. How is the life of a child worth only $250,000
because
in the legal community?
If a child dies as the result of medical negligence, the most the family can recover is $250,000. That's it. It's capped. And if that made sense in 1975, it doesn't make sense in 2013. It's way out of date and it's way out of touch. And it effectively means nobody's going to take the medical malpractice case against the doctor for causing the child's death. That's just a plain, harsh reality of where we stand today.
So they can recover lost wages and economic damages as a result of the medical bills. But your argument is if you're a child, there are no lost wages.
There's none. There's no economic value, unfortunately, for the life of a child. The only value is the value of that life to the parents, to the family. And if a child dies, their life is only worth $250,000. That makes absolutely no sense today.
What are the ramifications of that law?
Well, what's effectively happened is nobody brings cases. But more importantly than that, we're really interested in what is all about medical negligence and medical safety and patient safety. And patient safety today is in real trouble. A study about a decade ago by the Institute of Medicine found that there's about 98,000 deaths a year in the United States as a result of medical negligence. So we're launching this campaign to change the Micra law as part of a larger campaign about medical safety and about protecting patients in California from doctors. 38 years ago when this went into effect, it was a very, very different world. 38 years ago, we had a world where medicine was run mostly by Marcus Welby. Today, it's run by large corporations, corporate interests that run medicine. It's changed dramatically. There has to be a change to Micra, but there has to be a larger change to patient safety.
Now, why do you say patient safety has been endangered over the past 4 decades?
Well, for example, if patients are dying at the rate of about 10,000 a year in California as a result of medical negligence, there's a serious problem that we have to look at. So let's not just look at
that comes from where?
That comes from the Institute of Medicine going about a decade ago in its own study that it's conducted that had nothing to do with any of the parties that are interested in this fight. So it isn't just the Micra law. It isn't the $250,000 cap. We have to start looking at some other issues too. How are doctors disciplined in this state? Is there a problem with doctors and abusing drugs and abusing alcohol or performing surgery or taking care of you when you're wheeled into the emergency room at 3 in the morning? These are very serious problems that I think we need to take a broad look at. So it isn't just the $250,000 cap.
Do you have evidence that that cap has allowed doctors to go free without any ramifications of misbehavior?
Well, there's certainly evidence that nobody, and I mean nobody, will handle a medical malpractice case for the life of a child or the life of an adult. It's not just children, an adult who dies as a result of medical negligence, who works inside the house, doesn't work outside the house, has no economic loss. So as a result of that, there's no ramification for the death caused by medical negligence. And more importantly, the medical board does very little to discipline those doctors. There's very little oversight over bad doctors in the state of California today.
That's where some would argue that's where you should focus your efforts, at the medical board, as opposed to changing this law.
So we are. So one of the things we're looking at, and we're looking at several initiatives that we bring in the fall of 2014. And one of those initiatives is to improve the discipline of bad doctors. Another one, and I think it's very significant, is to require mandatory drug testing of doctors who have privileges at hospitals. So if you're a doctor and you perform surgery or you work in an emergency room, mandatory random drug testing will be required for those doctors.
That's based on what? You think that there are doctors out there who are all drugged up who are in emergency rooms?
Well, there's about 12 to 15% of the doctors, just like in the regular society, who abuse alcohol and drugs. We know that. But we also have seen studies where about 60% of medical negligence may have a connection to either abusing drugs or abusing alcohol. So why not test the doctors? Why not get that issue out there in the public so that doctors have the same standards that pilots have and truck drivers have and a lot of people that work in America today?
Ryan Kapitak, the president of the Consumer Attorneys of California. Thank you very much.
Thank you for having us.
Up next, a Silicon Valley entrepreneur who says the Micra law is in part responsible for the loss of his 2 children, and later a response from the leader of the California Medical Association when we return.